Hey out there, legal warriors. This is a very important video. I'm going to cover in this video why doing some type of class, doing some type of remedial measure is one of the most important things somebody can do if they're charged with a crime. So if you're interested in the law, if you're charged with a crime, stay tuned. This is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. I'm really serious about this subject. It's a little bit of the secret to success in defending most criminal cases. Now, this may not apply so much to major felonies because prosecutors have less negotiating leeway in major felonies. But let's face it, most crimes aren't major felonies. And one way that we can try to show the court and show the prosecution that we deserve some leeway, that we deserve some leniency, that it might be more okay to dismiss the case against us or a defendant, right, is to do some type of educational classes to better ourselves from the event, even if we feel or we are innocent. Let's face it, the prosecutor's job is not to let us go. The prosecutor's job is to respond to the case in some way, and that's the best case scenario. Some people might think the prosecutor's job is to convict me. Well, in one way it is, but I was a prosecutor for 7 years, and the way I thought about it, and the way I think most prosecutors actually operate in real life, is psychologically it's their job to respond to the case. And so when the time gets around to negotiate the case, the defendant is in a much better position if they've taken some remedial or some fixing it type steps to address whatever it looks like in the paperwork might have caused the situation. So what do I mean by that? Well, in some cases it's obvious. If somebody's charged with driving under the influence of alcohol, then it would make sense to have them get an alcohol and drug evaluation and have a professional evaluate the driver who's charged with the crime and make a determination what type of education or treatment might be useful so this doesn't happen again. And in fact, that's going to be required. One of the few times treatment is required, it is required by statute in a DUI case, unless the case is dismissed or something like that. So in a DUI type case, we could send someone for an alcohol and drug evaluation. Even if it says the person has no problem with alcohol, this is a one-time thing, they will still recommend an alcohol and drug information school, a little 8-hour class. And when we do classes, it is not an admission of guilt. I just got this question yesterday from a client, and it's a good question. It sort of feels like that is what the client said, and of course that is not an uncommon feeling. Well, if I'm doing something, that means I did something wrong. No. That's not how you should think about it. How we want to think about classes is I'm doing what I need to do to get out from under the government as best as I can, because the government has a lot of power to do things to us. If we get convicted in court, we can go to jail, we'll have a criminal record, we could lose rights, lose our job, lose our driver's license. So it makes a lot of sense to look at the bright side. Hey, if I do some classes like alcohol drug information school and evaluation, not only will it help my case, maybe I'll just try to learn something too, because I'm in this situation for some reason, right? As far as other types of classes, let's say someone's charged with a crime of violence, a domestic violence crime, an assault at a bar, anything like that. Well, there's anger management classes. There's an 8-hour anger management class. There's a 16-hour anger management class. There's something called DVMRT. We have videos on that, domestic violence, moral recognition therapy. That's a really powerful and inexpensive set of classes, 6 months of classes once a week, really good, $200 to $400 total. And so those types of things are things we can do to give the prosecutor an accurate feeling that they've responded to the case. In other words, if we do nothing, what is the prosecutor's only option? Imagine you're the prosecutor. Well, this person's charged with this crime and they want me to reduce it to a lesser crime or dismiss it. Well, that's not my job. My job is to prosecute this case. Now, I've got 50 or 60 other cases I'm worried about too today, so I'd like to resolve some cases so I can actually have a tolerable life, so I'm not working all weekend prepping trials. But if this particular defendant has done nothing, then I've got no choice but to try to prosecute that person all the way to get a conviction, because I'm not doing my job otherwise. If another defendant has done 6 months of classes, I'm more able to hear now the other version, their version of events about why they're not guilty or how they have no record, stuff like that. So if you're out there charged with the crime and your attorney wants you to do some classes, it's for a good reason. It's typically not because we think that you're some person in great need of that type of education, though we can all benefit from all these types of education, especially when it comes to thinking and how we see the world. It's that we want to have you get benefit while also benefiting your case, because we need to get a good result in your case. So why do we want you to do the classes? We want you to do them because it gives the prosecutor a way to respond to your case without having to convict you, because a prosecutor wants hopefully to do justice, and there's two sides to every story, but they are on one side and we're on the other. So many people can lose sight of the fact that it's not the prosecutor's job to figure out what really happened. It's an adversarial system, right? It's the jury's job, theoretically, to find out what actually happened and hold the prosecution to a burden of proof beyond a reasonable doubt if a case gets to a trial. The reality is, though, sadly, is beyond a reasonable doubt is just a bunch of words. They don't mean anything for real, right? We can have all the definitions of beyond a reasonable doubt, but in reality, the juries just convict who they feel like convicting based upon what they think happened. Occasionally you'll get someone that holds to the standard of proof, but in reality, those are just words. So what we want to do is we want to try to find a way to get a positive result for a defendant in a way that the prosecutor also feels is positive, so we can get a result that works for everybody. And one of the greatest tools in making that happen is some type of classes. So if your attorney asks you to do the classes, do them, and don't drag your feet and be mad about it. Get the most out of it, right? I share with my life all the time, and even here on YouTube, I've done all types of work on myself. I've been in all types of group counseling, things like that for years, and that's how I can sort of understand how I work, and therefore have a better idea of understand how some of the rest of us work. So that's why classes are so important. I really am passionate about this, and if you found this useful, please like and please subscribe. More people get to see it, and more importantly, if you have a legal problem, if you need criminal defense in Washington State, feel free to give my office a call. We've been doing this more than 20 years. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.